I wonder. Right.
Into DJ how like as the 10 like a year or so ago, it's about we're doing a series of it was like a cross that like DJ and something else permanent or something.
Yeah. They usually have the and whatever. We don't usually have kind of this broad open one, so it's exciting. You want to hear about your son? It's gonna be my clinic this fall.
Oh,
Yeah,
nice.
right in the fall, right? Yeah. In the spring, okay.
How many do you have it? How many students do you have?
10 per semester.
Okay.
Yeah, it'll be full time or almost full time. If they do the clinic and then maybe one. Started, I'll introduce you and kick things off.
All right, hello everybody. Welcome to the Environmental Law Institute's 7th session of summer school on environmental justice. We're so excited to see so many of you here in the room today. This is our last hybrid session of summer school. So we're located here in DC doing the session live in the ELI's office, but there's also a sizable audience online as well. So we're so grateful to all of you for being here, whether you're in the person or in the room with us or online. So a few notes about today's session before we get started. There will not be any slides today. Our speakers are just speaking in person. So for the folks online, no need to worry about finding the slides on our website. Today's session will be recorded as well as all the other sessions of summer school that we've had. So you can't stay for the whole session, or if you'd like to view any of our past 6 other sessions of summer school, you can find all of those recordings at eli.org. We do have one more session of summer school next week, though it will be virtual only, and that'll be on RCRA and CERCLA. So we highly encourage you to check that out as well. You can register at eli.org. We will be taking questions throughout today's program. So if you have any questions for the folks online, please submit them using Zoom's Q&A function. You can submit your question as soon as you think of it. There's no need to wait until the end. For our in-person audience, if you could hold your questions until we take questions, my colleague Sarah will be bringing a microphone around. We ask that you speak into the microphone just so that the online audience can hear you. And then lastly, just wanted to do a quick plug for ELI membership. If you've been enjoying the ELI Summer School series, we highly encourage you to check out membership. Membership is free for students, whether you're an undergraduate student, law student, graduate student, you can get free membership, which will give you access to all sorts of programming like summer school. We do monthly climate change briefings, monthly PFAS briefings, and all sorts of other things. So if you have questions about membership, please feel free to contact me or email events@eli.org. But with that, I will go ahead and turn things over to our moderator today, Mark Sabbath. He's a senior attorney at Southern Environmental Law Center, and he engages in advocacy and litigation to protect clean water, advance environmental justice, and fight fossil fuel infrastructure. He worked at their Virginia office. So I'll hand things over to you. Thank you so much.
Thank you. And thanks for having me and having all of us. And thank you all for coming. And those of you who are online, we're really excited to talk about environmental justice today. Such an important topic. I will just a little bit about where I work at the Southern Environmental Law Center. We are a regional environmental legal advocacy organization that focuses on and is rooted in the South. So we work in Virginia, North and South Carolina, Tennessee, Alabama, and Georgia. But obviously, some of the issues we're working on: air, water, land, wildlife, protecting the places and the people of the South, also have implications throughout the country. And so there's a lot of overlap with what we do in our region and what is going on nationally. And we work at the federal, state, and local level alongside partners in our region. And a major part of that work that we work on is identifying the most pressing environmental injustices in our region. developing relationships with communities of color, with underserved communities in the South, and then working with them to try to address those problems and try to find solutions. And so that brings us here to talk about environmental justice. It is, I think, a topic that under this administration has gotten a lot more attention, a lot more focus. I think it's something that the public is paying more attention to now than it has, but it is not a new issue, and it would be a mistake to call this like a hot new trend or something. This is a problem and a fight that has been going on for decades, and communities and advocates have been fighting for environmental justice for a long time. When we're talking about, and this won't be news to any of you, but when we're talking about environmental injustice, we're talking about the inequitable distribution of environmental benefits and environmental harms. A lot of time we think about the harm side of it. So we know, it's been well documented that people of color, lower wealth individuals are more likely to suffer the burdens of environmental hazards and environmental harms. So we know about some of the big stories that have made the news about Flint and Jackson and Cancer Alley in Louisiana. There are also just, I don't want to say every day, but common facilities that are cited, industrial facilities and landfills and other environmental hazards that are much more likely to be cited close to communities of color and people of lower income. On the flip side, those same communities are also less likely to benefit from things like green space, like affordable and accessible transportation and public lands. So the benefits are also less likely to accrue to those communities. And now, for a long time, but especially now, these same communities are also most likely to feel the effects of climate change. So extreme heat, flooding, and the effects of major storms. So environmental justice is an attempt to remedy that, to address that. And we'll talk about, all the different things that means in terms of the fair treatment, meaningful involvement of these communities in environmental decision-making. There are real challenges there, which the panelists will, I'm sure, go into, an absence of like explicit federal environmental justice laws, few state laws that address this, political headwinds, the fact that environmental justice is often pitted against economic progress or appears to be so. So what we'll be exploring today, and welcome to discussion with you as well, is what environmental justice means in practice. What are some of the most pressing environmental justice issues? What are some of the legal tools that are available to address them? How far have we come? Where are we heading in the future? And I'm fortunate to have two very distinguished panelists to help sift through all of that. Right next to me is Sarah Colangelo. She's an associate professor of law at Georgetown University Law Center, where she also directs the Environmental Law and Justice Clinic, and researches and writes about environmental law and environmental justice. Through her work at the clinic, she and her team of staff and students represent communities, indigenous populations, environmental and social justice organizations on environmental justice issues, climate change, pollution control, natural resources, a host of issues. Also a former colleague of mine from the environmental enforcement section at the Department of Justice, where we both worked before our current jobs. Next to Sarah is Roy Prather, a principal at Beveridge and Diamond in their Baltimore office. Roy represents businesses and public sector and entities in environmental and commercial litigation. But importantly, he also counsels clients on a host of environmental justice issues, including developing creative solutions to community concerns regarding environmental justice. Also mentioned, he's also a founding member of the Black Big Law Pipeline, a nonprofit made up of senior Black attorneys working to promote positive outcomes for Black attorneys in large law firms. And Roy and Sarah are also connected because Roy teaches an environmental justice course at Georgetown Law. So I will, before I turn it over to them, just a little roadmap of how we're planning to organize this panel. Sarah's going to talk about history, the development of the environmental justice movement, and some of the early approaches to addressing these environmental injustices. Turn it over to Roy, take it from there, bring us up to where we are today, cover some of the current administration's initiatives on environmental justice, and talk about how some of these tools are being applied in practice, not just the administration's tools, but other environmental justice tools, and how that sort of plays out in practice. And he has the benefit of being able to speak from both a private sector perspective, also on behalf of municipalities, so he brings that perspective as well. We'll turn back to Sarah to talk a little bit more about some of the legal tools that are available, and some of the interdisciplinary nature of environmental justice and EJ advocacy. And then we'll sort of open up more of a roundtable discussion about some current issues in environmental justice, about, again, really trying to talk about the practice of environmental justice, what it looks like, what it involves, what some of the challenges are. And then we'll incorporate into that your questions here, and if you submit some in the Q&A online. So we welcome your questions along the way. And with that, I will turn it over to Sarah.
Great, thank you so much, Mark. Thank you so much to ELI for having me back to summer school. Before this, I've done the Clean Air Act, the Clean Water Act, and now environmental justice for ELI summer school. And it's just a delight every single time to be with this audience, to be with the audience online, to have students, maybe future law students, current law students, people early in their career thinking about practicing in these areas. So it's just always a great chance to get to speak to this audience. So as Mark mentioned, I'm going to do a little bit of what I'll call foregrounding for our discussion by talking about sort of the overarching principles in environmental justice, and a little bit about how did we get to where we are today? What's the history of the movement? But I'm going to pick up on a thread that Mark spoke about earlier about the definition of environmental justice. So when we're talking about that, I just want to put out on the table some really concrete ideas about what we're talking about, because there's no single agreed upon definition of environmental justice. But the vast majority of definitions that we have, of scholarly approaches that we have in this area, of activism approaches, they all concern the foundational principles that every person has the right to live in healthy environments, to be protected from disproportionate amounts of pollution, to enjoy their proportional amount of environmental benefits, as Mark indicated, and participate in environmental decision-making that will affect their lives. I also want to highlight for you that EPA's definition of environmental justice under this administration has advanced appreciably. So it's very detailed now, and I think it really deserves to be read, at least in part. So environmental justice, according to EPA, encompasses the just treatment and meaningful involvement of all people, regardless of income, race, color, national origin, tribal affiliation, or disability, in agency decision-making, or in other federal activities that affect human health and the environment, so that people are fully protected from disproportionate risks and hazards, including those related to climate change. Now, these are new things that EPA's added: climate change, cumulative impacts, and the legacy of racism or other structural or systemic barriers, and have equitable access to healthy, sustainable, and resilient environments to live, play, work, grow, worship, and engage in cultural and subsistence practices. So a much more nuanced and detailed and expansive definition of environmental justice now, which I think really well captures a lot of threads that we've seen grow in the movement over time and worth highlighting. The other thing to know is that these ideals, and you might have picked up on this from the definition, these ideals don't come from conservation-minded ideals that animated the passage of our foundational environmental law. So I always, set that out front for folks who come in from the environmental side of things. These ideals really came from a civil rights-oriented perspective, and they grew out of the consistent marginalization of non-white and under-resourced communities, and the sizable and persistent disparity in the distribution of environmental burdens and benefits, as we've mentioned. And again, just picking up on some of what Mark said earlier, we've had scientists and sociologists and researchers and activists present evidence over and over again about these disparities, especially in environmental burdens. And it's really every burden you can think about. And Mark was right to bring up climate change, the effects of climate change, but anything you can think of: air pollution, water pollution, siting of hazardous waste facilities, lead pollution, pesticides. They've documented rodent exposure, rat bites, noise pollution. Everything is correlated both to race and lower socioeconomic status, but the single biggest predictor, most significant predictor of exposure to these hazards over and over again is race. And so we're going to touch upon some of the challenges that we face in environmental justice because these issues are so closely correlated with racial identity. That presents a lot of challenges when you have, for example, and I'll preview, spoiler alert to some of my later remarks, when you have a Supreme Court that said we can't account for race when we're making certain decisions. That presents a real challenge for us. But the environmental justice movement responds to these disparities, and it draws upon aspects of the civil rights movement, social justice, labor justice, and environmental movements. It intersects policy, law, economics. That's, I stay away from numbers a lot of the time. I'm a lawyer, but you should know that it intersects all these fields. And when we talk about environmental justice, we need to think about the federal scheme, the federal laws that intersect here, but also state and local laws play quite a large role in advancing and addressing environmental justice and fomenting actually environmental injustice as well when we think about racialized issues in zoning and land use. And then one more thing I'll say about this is that the role of lawyers. The role of lawyers is quite nuanced for the environmental justice movement. The late leader in this space, Lou Cole, coined the phrase "lawyers on tap, not on top," which means we are not driving the strategy. We are not going into, at least for my practice, we're not going into communities and telling them what their problems are. We have a specific role. We do have value to add to the movement, but we're just one strand. And there's a lot of movement organizing and other types of strategies that are involved in advancing environmental justice, not just law and lawyers. So let's talk about some of the earliest environmental justice advocacy. Really, even though they wouldn't have called it environmental justice at the time, we tend to trace this back to the 1968 sanitation strike in Memphis. That was one of the first instances of environmental justice activism. Now we can locate that looking back. But the big one that people tend to talk about is the 1982 weeks-long protest against the siting of a carcinogen contaminated soil, it was PCB contaminated soil, in a predominantly Black community in Warren County, North Carolina. That following on the heels of that was the 1987 Toxic Waste and Race report. And that was really so fundamental, quite a landmark report that demonstrated the link between communities of color and under-resourced communities and the siting of hazardous waste facilities. By the way, that's still the case today. Black Americans are something like 75, if someone knows a percent, but I think it's 75% more likely to live near one of these facilities still today. It's still the case. And people who authored that report are still in the fight. Charles Lee is still at EPA leading the charge on these things. More foundational things to know about. In 1991, the delegates to the first National People of Color Environmental Leadership Summit drafted 17 principles of environmental justice. I encourage you, if you haven't engaged with this document yet, it's very short, but go take a look at it. It's very expansive. You heard the definition that I read that was expansive earlier. Look at this, it's even more. And it's important because these were leaders at the time speaking their truth and memorializing what was important to them at that moment. So it's worth taking a look if you haven't seen that. But among other things, it affirms the right to self-determination, to be free from environmental hazards, and demands the right to participate as equal partners at every level of decision making, among, as I said, a host of other ideals. In my final key sort of framing point, before we turn to some early ways that we tried to remedy environmental injustice, is a point about intersectionalities. So as Mark indicated in his remarks, there's no single environmental justice law. So instead, what that means, so I'll say at the outset, that's full of peril, but also full of promise, okay? So what that means is that instead, we find ourselves importing some of those ideals I just mentioned into different statutory regimes, okay? So we're gonna talk about that as we sort of unpack what the practice of environmental justice looks like. But I just want to be really concrete for a moment. Without that overarching law, we're kind of plugging holes and gaps and finding barriers and getting around those barriers in a lot of different types of law. So it's one of the key features of environmental justice work, okay? So that means in practice, environmental justice advocates have tried, and sometimes more often than not failed, to import environmental justice analyses or goals into different legal regimes. So if we look through the history of litigation, for example, in the federal state levels, we see a lot of different types of attempts to get at environmental injustice through laws that weren't designed for that purpose. Okay, and so what that means in practice is very often when you're litigating through a law that wasn't designed to help remedy a certain situation, even if you win, you typically don't get complete redress. And so we see that a lot in this area, and I want to highlight that out front. So let me just sketch high level a couple of the historical legal strategies, and I think that'll pivot well into Roy's remarks. And later, as Mark indicated, I'll talk about some of the more common strategies that we use today, which of course are much broader than litigation. I'm going to talk about some litigation things, but we'll touch upon other advocacy avenues as well. So in the early days of environmental justice legal work, as I mentioned, this movement really has its roots in the civil rights organizing principles and strategies. And so when people thought about suing based on pollution disparities or what they thought were examples of environmental racism in the siting of these facilities, they looked to the civil rights movement for their legal strategies. So one of the first things that they tried to do was to bring constitutional challenges under the Equal Protection Clause and Civil Rights Act challenges. Another spoiler alert, those were not very successful. Okay, so what happened? So one of the first major cases to be recognized as an environmental justice case, Bean versus Southwestern Waste Management out of Texas, was one of these fights. And it was a fight to try to prevent the siting of a facility in a majority Black neighborhood by invoking the federal Constitution's Equal Protection Clause. But the Supreme Court's cases in the 70s restricted the application of the Equal Protection Clause, requiring proof of discriminatory intent to establish that constitutional violation. And guess what? Almost never exists. Explicit evidence of discriminatory intent, okay? And so what can seem very obvious by the actions of public officials and by the disparate impact these sightings are having aren't enough to meet that threshold. The threshold is just very, very high, even where we have plaintiffs who offer statistical analyses, historical analyses, as the plaintiffs did here. By the way, as a side note, the sociological analysis that took place here was how Dr. Robert Bullard got his start. His wife, Linda McKeever, I think that's her middle name, Bullard, brought the suit. And he was a sociologist who worked on it, and he is known as the father of environmental justice. So just a side note. So even where we lose, sometimes we're launching people into this space that really, really powerful movement leaders. But again, meeting that threshold was really difficult for these plaintiffs and has proven so in the vast majority of cases that try to invoke constitutional protections. The other legal tool that looked really promising was the Civil Rights Act. In Title VI of the Civil Rights Act, which prohibits discrimination based on race, color, and national origin in programs and activities receiving federal financial assistance. So that includes states and state agencies that might be receiving federal funds for infrastructure and things like that. I'll note, because I think we'll come to it later, that most federal agencies, including EPA, have promulgated their own regulations implementing Title VI. And those tend to prohibit programs or actions or policies that would have the effect of discrimination. And that becomes important later when we talk about Title VI actions. But once again, the Supreme Court sort of rained on the parade of using the Civil Rights Act as well. In a case called Alexander versus Sandoval, they ruled that individual plaintiffs don't have the ability to bring a claim on their own, what's called a private right of action, for violations of Title VI regulations based on disparate impact. So now the upshot is that if you want to bring one of those cases, you have to file an administrative complaint directly with the agency, which we can talk about a little bit later. So there are setbacks. There were early setbacks in litigation strategies, but that's not where the story ends. We're only a little bit into this. I'm going to turn it over to Roy, and then we'll add a little hope. We'll maybe inject a little hope into the conversation. Yeah.
Thanks, Sarah. So she laid the groundwork pretty well there, and I'm going to fast forward a little bit, but first have one little note observation that I think will inform where we are now, which is to say that similar to the civil rights movement, you have a lot of activity from advocates, you have activity in litigation, community organizing, not much success in litigation, but over time, awareness is increasing, attention is increasing. And ultimately, even if you're not winning, say with the Supreme Court, you are winning attention, you are winning focus of people who now maybe weren't paying attention before, are giving it greater attention, or thinking about some of the issues associated with environmental injustices, and then taking steps to act on it, even if there isn't formal laws in place to address them. And so I say all that to say, particularly with respect to the Biden administration, that really kicked off what I would call kind of the most activity we've seen, particularly on the federal side of things, in giving attention to addressing environmental justice concerns. There had been some action, a prior executive order from President Clinton, which gave it attention, right? But didn't really have, I won't call it teeth, but really action, as much deliberate action behind it, because there was no clear instruction of what was expected of agencies to actually incorporate environmental justice, going forward. And that all shifted dramatically, really right after President Biden entered office, when he issued an executive order, basically making his promise from his campaign solid by saying essentially that he was going to be taking what they called a whole of government approach to addressing environmental justice, which is to say, kind of echoing what Sarah was referencing before about this kind of intersectionality and kind of cross-disciplinary, interdisciplinary aspects of environmental justice, to really get at the impacts, the harms, the historical issues that really are all tangled together when you start talking about environmental justice. It can't be something that's just siloed in, say, EPA, for example, because there's only so much that EPA can cover in its remit, but it touches issues that relate to Department of Health and Human Services, the Federal Energy Regulatory Commission, and so on and so forth. And really what it emphasized, and this touches on much of kind of the work that I do, the necessity of thinking about environmental justice, not in the context of what's the law say and checking the box to kind of fit the law, but really a lens or a view that you have to approach every issue to ensure that you're accounting for the historical impacts, the historical effects associated with activities that have occurred or are being planned to occur going forward. So much of my work is actually, if they haven't been asked already, asking the questions to make sure that people are thinking through those issues, and then also making sure that they're thinking about all of the potentially impacted communities and stakeholders, because there's no just one monolithic group that you can look to oftentimes when you're talking about these issues, to make sure that at the very least they've been given consideration, they've had an opportunity to weigh in, to speak, and be given access to information so that they can be informed about how whatever activity you're dealing with or past activity affects them. So with that aside, going back to the administration, basically what the Biden administration really focused on primarily is an increased attention on ensuring that the benefits associated with various forms of investment are actually being distributed to communities that traditionally have been disadvantaged because of the siting issues that were previously referenced, because of the activities that historically have been such a heavy burden on those communities. One of the ways that they primarily did this was through the Justice40 Initiative, which effectively guaranteed or promised that 40% of funding for various projects or activities, the benefits of those would be directed to communities that had been identified as disadvantaged. To facilitate actually identifying what communities are disadvantaged, they also created a tool called the Climate and Environmental Justice Screening Tool, which basically was a kind of newer, slightly different version of what EPA had developed before, called EJ Screen, which collected a ton of demographic data about basically the entire US using census information, as well as certain environmental indicators, so air toxic screening tools, proximity to hazardous waste sites, things of that nature. And then you could just plug in an address and either that specific location or a certain radius around that location, and you could get information spit back to you to say, okay, in this particular area, here is the percentile ranking of the risk to this particular population relative to the state and nationally, which was useful so that, at least with respect to my practice, you can identify early on whether there are more questions you need to be asking about what's going on in that place, because it doesn't really tell you what the causes of some of those results are, but then will assist in what we call ground truthing, which is to say, what's actually happening on the ground with this community? Are they, has there been for decades certain industry here that's led to increased emissions in the environment? And maybe those facilities are no longer there, but the impacts of that are still being felt. How do you address that? How do you speak to that? I call it CGIST, but the Justice40 related tool essentially takes a similar look, but also goes a little bit further to identify certain types of indicators of potential disadvantage, such as language isolation, low socioeconomic status, race, low employment numbers, things of that nature, to identify, okay, a particular community is disadvantaged relative to the other communities in the vicinity, so that when, let's say, a company is seeking funding for developing a project, they will be locating it either in the vicinity of or nearby that community. They now have to create a plan to show how the funding, or at least a substantial portion of that funding, will go to that community and what that will look like. And that then touches on that whole of government approach. Think, for example, of the Federal Energy Regulatory Commission. If you have, renewable projects, right? So say solar, wind, all of these things that everyone's heavily investing in relation to transitioning from fossil fuels. But another side effect of some of that development is many of the siting locations for those projects run the risk of repeating some of the same trends that we saw with respect to landfills, other activities, where, again, the burden of having to use all this land that then has emissions associated with it, impacts to water, now being cited, again, near disadvantaged communities. And so what the administration then has required is the creation of, and FERC in particular, community benefits plans. In order to get approved for any project, you have to prepare a plan that speaks to not just funding that can be provided, but actually how do you anticipate rolling out some type of project or plan that's going to positively benefit that community. And that can be jobs programs, that can be educational benefits that are being provided through funding, that can be access to additional resources, not even specifically related to that particular development, but just investment into the community. So with that understanding, it's been a time now, and it's still rolling out because there's been a bunch of money through the Inflation Reduction Act and other legislation to provide a lot of funding available to actually address some of those needs. But one of the challenges that has existed anytime there's been an effort to address issues that communities face that lack access to information, access to resources, is making sure that the resources actually get to them, make sure that they're actually aware that those resources are available. So there's also been redoubled efforts to do basically just moving out into the community to actually inform people of here's what's going on, here's what's available to you, and also requiring when there's a company that's planning to do a project, or let's say a municipality needs to expand a particular operation, that there's actually a step involved where the community is actually informed of what the plan is to do it, what the anticipated impacts are, what steps are being taken to mitigate those impacts. And so really the attention piece, I would say, is the one that has most dramatically expanded. Litigation, I won't really touch on kind of present litigation. I think Sarah will, when I turn back to her, she can touch on some of those. Still not the most success in that realm, just because you're dealing with a much more rigid framework for how these things get addressed. But because you have the activity of, like I said, the attention, the engagement, and then others taking action, there are other ways besides having the US Supreme Court, issue a ruling that addresses this, including at the state level. So, one of the challenges that you find in trying to address some of these impacts, particularly in the litigation context, is if you're suing under the US Constitution or a federal environmental statute, you're in federal court, you're dealing with, that structure to address those issues, when many times those issues are very local, right? So the way to actually address them is probably going to be in relation, or at least in coordination with, who those local authorities are, where it could be a zoning authority, it could be various city, town, county level operations, and that activity can go on irrespective of whether there's litigation or not. And so much of what I'm doing is often identifying who those stakeholders are, making sure that all of those end up at the table so that you can talk about ways to address the concerns. Because with the attention piece, now at the very least, you're getting everyone to have at least some understanding that there's an issue that needs to be addressed. And then you can have a conversation about how to address it, rather than the rigid framework of, when you have a litigation, okay, you get compensation. Well, what does that mean and what does that look like? Or if you don't get compensation, you get injunctive relief. Well, what does that look like? And courts are not really trying to be super specific about how that works, which makes them even less likely to award relief, because they don't want to have to try and figure that piece out. And in the meantime, everyone's still trying to sort out on the ground what needs to happen. And so the benefit of the additional attention from both the federal government and states is that there's now active efforts to require, sometimes just encourage, certain activities that are meaningfully targeting addressing historical impacts related to environmental justice. In the state context, you have things as far as like the state of New Jersey that actually put EJ legislation on the books. So now there are specific requirements in place for basically anyone operating within the state, that they have to meet those requirements with respect to reporting, with respect to transparency to the community about impacts, and with respect to how they're going to mitigate those impacts. For states that haven't gone that far, they still have state agencies that now have the attention, so they're asking the questions, right? So what would have traditionally been, run-of-the-mill permitting process, where you need a permit to continue operating a particular facility, and everything still seems to operate the same way it did 10, 15 years ago, and they say, okay, here's your new permit. Now, in that process, they're saying, okay, well, we have better monitoring now than we had before, and it looks like we're detecting X, Y, and Z constituents. What are you doing to reduce the level of those constituents? Because it exceeds, in this area in particular, a much higher percentage than in the other parts of the state or the other parts of the city. And until that gets meaningfully addressed, we can't issue that permit. So then there's a conversation where now people need to go and leverage, evolving technology, which has improved over time anyway, to make sure that now we're actually mitigating those potential harms that have been identified. One of the ongoing challenges remains that you can't really operate without having an impact of some kind. But what that means looks very different depending on the questions you're asking and the priorities that you're establishing. And so, when I'm advising municipalities, I mean, all of the people in that community are their constituents, right? They are responsible for, in some degree, the safety of the people within the area. But impacts or development or resources that are needed still need to be provided to everyone. How do you make sure that you're able to provide everyone with the resources and not force that burden onto people who have been historically burdened over time? Which there are no easy answers to those questions, but the fact that they're being asked and others are engaging and trying to figure out how to best approach it is a major step forward from where I saw things even just 10 years ago when I was working on environmental justice related issues. With respect to companies, the other interesting thing that I'll say that I've seen, and this again reflects that attention piece that I mentioned before, they're always individual people who care about, think about, look at, examine certain issues, and those issues end up being very significant to them. But when you're within a large organization, it may not get the same attention that that individual person gives to it. Well, a lot of these EJ issues, given that the federal government kind of, put their flag in the ground and said, this is significant, this is important, and everyone should be thinking about it, including every single agency, anyone who contracts with the federal government, all of those things. Well, now it forces the hand of everyone else who may not have even just bothered giving it the attention that it required to engage in those conversations. And once that happens, then now when the impact is in your face in a way that you didn't have to think about before because you were focused on other things, now you're almost forced to do something, or at least acknowledge that you're not willing to do something, which has its own implications, right?
Mm-hmm.
And so ultimately it has led to, let's just say, a lot more conversations for me with a wider range of folks about how to think about, how to communicate about, because not having a kind of clear-cut, statutorily defined definition of environmental justice can also present its own kind of unique issues when people start thinking about prioritizing limited resources or prioritizing the focus of trying to mitigate or address potential harms. But all that said, I don't think it can be denied that overall, the attention and the time being spent to actually at least engage on those issues has increased. And I don't think, irrespective of, previewing ahead a little bit, but irrespective of administration, honestly, that attention's not going to go away, right? Because other states have proposed legislation, EJ legislation on the books, and many of them that will pass. Some cities have said, I'm not waiting for the state. They're putting forth their own EJ legislation or passing it. And as that develops over time, then others see those examples and they model it either after that, or they say, this is what worked there, this is what didn't work, we'll do it this way. But one way or the other, the attention's there. And really, like I said, that the Biden administration putting such a heavy focus on it made it that much easier for those who were already advocating for it to kind of justify pushing it even harder on it. And at the same time, I'll give credit to, some of my clients where they had, let's say, an interest in understanding better how to best address those things, but didn't know who they should be talking to, what they should be talking about. And there was reluctance to say anything publicly because you don't want to misstate something, right? Well, now there's at least, I'd say a curiosity and an interest because EJ touches everything. So if you think of things like sustainability or, ESG, which is now kind of a big buzzword. EJ touches on pretty much every single facet of that piece as well, whether it's the environmental piece, the social piece, or the governance of, who's making decisions, how are you structured to make sure that you're actually allowing for those that have traditionally not been given opportunity to participate in various activities of the corporation or the industry to be involved. And so all of that, at least again, suggests to me that the attention is not going anywhere. One of the last things I'll highlight, and then I'll turn back to Sarah to talk a little bit about on the ground, kind of what she's doing, is what I've seen, at least so far, as things have continued to progress. The inability to leverage a statute, at least in most contexts, or a particular regulation. I mean, we're lawyers, so it just means that you find another creative way to do the same thing you wanted to do if you don't have a set framework in place. And so, agencies, EPA is a perfect example. You look at the traditional environmental statutes, doesn't say environmental justice anywhere in there, but you have a framework for, let's say, permitting, and it specifically requires you to ensure that you're, addressing the, I think it's Clean Air Act, Clean Water Act, all of them maybe, but essentially protecting the public's health and safety, right? And so what that means is up for interpretation, but it surely would include ensuring that disproportionate impacts associated with an activity would not be forced on any particular population, right? And so as part of their permitting process, now that can include, you should be forced to study what the impacts are, what the cumulative impacts are, and then also describe to us what can be done to mitigate those, right? Now, obviously, there may be questions about, does that actually fall within the full scope of EPA's authority? Depends on who you ask right now. That's all still up in the air. But that's the type of creative thinking that makes sure that those issues are still inserted into the process. And if they're unsuccessful and all of a sudden EPA's authority is limited in some way, doesn't really change what authority the state has when they're looking at their own laws and trying to enforce it. And oftentimes you'll have a New Jersey who'll say, yeah, we've got our own law. And so it doesn't really matter what EPA thinks about this piece because our Constitution says this and our state law says this, and they're going to do what they're going to do. And so the issues are going to be addressed one way or the other. Now, I'm not going to be overly, optimistic in saying that, oh, all 50 states, everyone's going to have a law just like New Jersey's. But again, just because there are different ways of doing it doesn't mean that everyone won't have to, in some way, account for it, because ultimately it affects everything from investment for that a state receives, it affects investment that companies receive. Even just public perception. No company wants to be labeled with having ignored communities that have been historically disadvantaged, and then adding to that burden without even doing so much as investing in a way to mitigate it or provide some opportunity to address it. And so where we are today, I would say, is kind of in the middle of significant shift in focus that suggests that environmental justice is going to be woven into the way that environmental concerns in general, whether that's climate or other issues, are addressed. And that just means that everyone will develop their own lexicon for addressing it, because again, not all of these things have clear-cut definitions, but the one thing that seems to be clear is this idea of fair treatment, meaningful involvement, all of those kind of fundamental pieces of really that civil rights underpinning is now basically being ingrained into the thinking of how to address these issues. And with that said, I have some other examples potentially that I might share, but I'll let Sarah talk a little bit first about really on the advocacy side of things, kind of the work that's going on, how that looks now.
Yeah, thank you so much, Roy. And
Did you want to jump in?
Well, I just had there's one thing that, no,
Felt
that's
you
okay.
breathe.
Yeah. I was just intrigued. It's something you said in the middle about, because I focus on permitting a lot too. And I was interested when you said, you were talking about facility that might be renewing its permit and maybe didn't think before about what the disproportionate impacts might be, but now in renewing it, I was interested in, my experience has been where there is either efforts by industry or by the state in putting these requirements on facilities to consider this, it's with like, where are we going to put the plant? Let's think about the impacts on, the surrounding community. Have you seen examples where even like the renewal of a permit, so it's already there, it's already operating, but when the permit is up for renewal, either, again, the industry itself is thinking about this, or the state or locality is requiring them to think about what the impacts are?
Absolutely.
New
So,
Jersey, right?
yeah, well, New Jersey just requires it
Yeah.
at this point,
Right.
even for renewals. So, in the context of a new permit, it's much easier to, engage and essentially require a certain level of analysis and incorporation of those considerations into the permit. But for the renewals, at this point, what I'm seeing is that those same questions are being asked, because the real issue is that if you don't factor those in, there's a public comment and notice and comment period for all these permits. And then the permit will be challenged by Sarah, potentially. And when it's the state that has the delegated authority to issue the permit, EPA may step in and say, we have concerns about this permit. It shouldn't be issued until these issues are addressed. Either way, this permittee is sitting back waiting to operate, and they can't do it without their permit. And so the longer that drags out, the worse it is. So they'd rather figure out what are all the issues that we need to look at. Let's address them all now so that we can actually have this permit issued on a reasonable timeline, rather than have this drag out into litigation, permit appeals and all of this for years, right? And so there's, a little bit of self-interest in there, but also attention on the issue, because before it wasn't being brought to their attention, or when it did, it was in notice and comment. And so now they're a little bit behind the 8 ball, because they're trying to deal with it after a draft permit has already gone out. So yes, in the renewal context, it's definitely being factored in as well. And I'm actively working with both state agencies and permittees to, on the front end, have those analyses occur so that everyone is comfortable, because the state doesn't want EPA to tell them that the permit they issued is not good either, right? So making sure we're addressing all of those issues so that everyone's on the same page, and we're also communicating with the community about it in advance, so they don't see the permit and say, hey, what's this? This is happening. You're adding this to this facility. Nobody told us. What's the impact of that? Should we be concerned? All of those questions can be answered, through better public participation and transparency on the front end. So
Well, to get that emphasis on permit renewals and not just new permits to some other
Right.
states as well.
Right. Yeah. Yeah, well, this is great. And I will try to weave some of the points in that I heard that I think are just, I would agree wholeheartedly with what Roy said. And just to pick up on that last thread about environmental justice moving forward, really being woven into the fabric of environmental practice across the spectrum of what we do as environmental lawyers. That's wholly the reason that one of the many reasons that we now have a singular environmental justice focus in the clinic. I have a future clinic student here today, which is so exciting. But I truly believe, just as you do, that every lawyer who practices in this space needs to understand these issues, needs to be thinking about them in a proactive way and not adding it on to the analysis after the fact. So that's a really important piece that Roy brought out. So one thing I'll do is I'll just mention some of the other advocacy avenues that we pursue besides litigation before turning back to those claims, just because, as Roy mentioned, this is really a space for creative problem solving. It's one of the best things we get to do in my clinic. And when I pitch the clinic to students at Georgetown, I really emphasize that we are creative problem solvers. A community or an indigenous population, and sometimes even some of the organizations that we work with, come to us with a real problem on the ground. They don't often come to us and say, hey, I have this violation of the Clean Air Act over here. We're problem solvers. And so we bring a host of solutions and legal levers to the table. So I just want to mention a couple of those. So one of the things that we do besides sort of litigation, or I think of litigation adjacent work, is get involved in the regulatory process. So that might look like commenting on proposed rules from federal agencies. It might look like commenting on permits, which I'll talk about an example of that in a little bit. It also might look like petitioning federal agencies or state agencies to do something. It could be as simple as disaggregating data that the agency is going to collect or generate or disseminate to the public by race, disaggregating that data by race so we can start to understand really what that burden is looking like on various populations. It could be as complex as saying, hey, there's airplanes that are running on leaded gasoline. That's not regulated yet. And so there was a petition for rulemaking early on in the Biden administration that related to that issue. So those are regulatory avenues of change that we can look at. There's lobbying that can occur at the federal and state level as well, in the local level for that matter. So talking to state legislatures about the importance of making small tweaks. It's not just for a new permit, it's for a permit renewal that we need to have these analyses be required. Things like that are really powerful ways that we can quickly, I think, enact a lot of change. We've seen great success actually in our own backyard in DC. We have the Environmental Justice Amendment Act of 2023. All these acts need a little bit of tweaking to make sure that they operate the way that we want them to operate effectively. But we're starting to see more and more of these things happen, not just at the state level, but the municipality level. And then there's also really simple things that we can do, and we can show up in spaces where agencies are asking for community expertise, for people to weigh in on what they're doing now, which is a new opportunity. Our agencies are activated and engaged, and no matter what happens for the foreseeable future, agencies are supposed to act based on the information that's in front of them. And so we should take this opportunity to comment. We have the DOJ Environment Division is hosting listening sessions and soliciting comments. The Department of Energy is actively soliciting comments right now on their environmental justice strategy. And the DOE one is open for written and oral comments, I think until July 31st. So Google it, find it, check it out, get involved. You can do it right now. You don't even have to be a lawyer to do that yet for the students in the room. So with that, I want to turn to thinking again about these creative solutions. And so I'm going to give you a host of legal strategies, some litigation adjacent, some straight up litigation, so we can get really concrete about the practice of environmental justice. But I'll just say at the outset, and I'm borrowing this from sort of a great practitioner in this space who said this when I invited him to Georgetown to speak. And we hosted a joint storytelling and advocacy session at Georgetown for environmental justice leaders. He was talking about one of his own friends and mentors and saying that environmental justice is a mindset. It is something that lawyers have to be thinking about constantly when we're practicing law. And so that means it touches upon a lot of different things. And so I want to name some of those points of intersection that we should be thinking about. It touches upon civil rights, of course. It touches upon human rights, health justice, reproductive justice, disability rights. It touches upon, actually, it has a lot of touch points with the carceral system as well. And so there's a lot of interacting pieces here that we need to be aware of when we're operating in these spaces. And I spent a lot of time thinking about that. Just to take one example from my own practice in the clinic, we helped bring the concerns of some indigenous populations. They don't have federal recognition yet, who are along the coast of Louisiana and facing forced climate displacement. We brought their concerns to the interim. We helped, actually, it was a great coalition on this complaint. We helped bring their concerns to the Inter-American Commission of Human Rights, right? So we're now pulling a human rights lever for change in an environmental justice, climate justice, energy justice context, okay? So it's really thinking creatively about our options. But there are options that have been a part of environmental law for a long time that we can really start to leverage them to advance change. So I want to give you a couple of examples of that. One great example of something called a citizen suit, which is where it's termed a citizen suit, where communities and residents can try to enforce environmental laws against polluters. There's a great example from 2013 that I wanted to highlight for you, where residents of a historically Black community in Rochelle, Georgia, sued the city under the Clean Water Act to address a truly dilapidated municipal wastewater system. So the residents in that case were represented by attorneys at Earth Justice. And they were alleging that the city was discharging pollutants in violation of the Clean Water Act, which governs the treatment and conveyance of sewage. And the residents and the attorneys of Earth Justice did a fantastic job of putting before the court in its complaint and in their notice of intent to sue, just a catalog of broken pipes and manholes and lift stations and all of these things from which sewage was flowing through the streets, flooding yards every 3 or 4 months for decades, flooding the basement of the church where people were worshiping, driving people from the fishing stream that they had fished at with their families long term. All of it ruined by these long-standing discharges. And so they brought the suit, and the suit is such a great example of the leverage that litigation, even if we haven't had all that much success with litigation, sometimes litigation, filing that suit can provide leverage. And in this case, it forced the city to the table. The city ended up settling and agreeing to create these changes in the municipal wastewater system. I'm sure not as I wasn't part of that case. I'm sure, it's never as fast as we would like to deliver that change, but there was a settlement in that suit. What makes citizen suits so difficult, though, in practice is that they require a lot on the community. And that was something that Roy brought up, and I want to just pull on that thread for a moment and think about what that requires the community to identify violations. In this case, I bring this case up specifically because there's sewage in your yard. Something's wrong. You can see something's wrong. Now think about the Clean Air Act for a moment. What would it take to establish a violation of the Clean Air Act? You can't see the pollution. Maybe you can smell it, but more likely than not, you just know you don't feel good. You know that your family members may be getting sick, but it's very hard to establish violations that might require quantification of these emissions, or when you have cumulative burdens where it's not just in your home, you're breathing polluted air, but you're breathing it on the school bus, in school, in your workplaces. These are very hard issues to try to remedy through a legal lever like a citizen suit. The same is true if we were to pursue action under tort claims. So this is civil liability. So, and that's been something that people have tried to do for quite some time. Again, a mixed bag there with not much success, but some success. So we have had people try to bring claims under theories of trespass, negligence, and battery actually as well. But so far we've seen nuisance claims be the most successful. So that a nuisance constitutes an unreasonable interference with the use and enjoyment of property. So think about pollutants coming onto, in the form of air, water, things like that, onto one's property. Again, this is really challenging. If it requires the plaintiffs to establish what's called causation of harm, how do you isolate one form of pollution that might be harming you when there's a myriad of sources all around you, creating this very likely synergistic effect on your health and well-being in your community? Civil litigation is time intensive, it's resource intensive, and it can be very intrusive, especially if it might require medical testing as well. We've talked about permitting challenges, and those are still going on today. In fact, it's a really common form of environmental justice challenges that start on the the administrative front, administrative process front, and then sometimes transition into litigation. Why does this still happen? Well, we still have zoning and local land use laws that are very often driving these sources to continue to be permitted in these same places. And so, as Roy was saying, environmental justice remedies, often we need to think about remedial action on the local and state level to try to solve these very local problems. But from the permitting challenges, I was going to actually mention the New Jersey law, so thank you for mentioning that. But I'll give you sort of again, I like to inject a little hope, give you a great example of success, and that's the 2020 decision, Friends of Buckingham. Just a great decision. I have all my students read it. It just so well articulates the intersection between federal and state laws that have this touch point, that have this intersection when you're thinking about permitting. And the articulation of the laws was so clear. I actually had a student once say that they didn't understand how the Clean Air Act worked until they read how the judge wrote about it. So read this decision. If you get into environmental law, for anyone who's in the room and you're confused about the Clean Air Act, go read this decision.
You might still not understand how, but it is definitely helpful.
But it's very, very helpful. It's just a beautifully written decision, and it just crafted so well. But there was a coalition of concerned residents and environmental advocates who successfully challenged the Virginia State Air Pollution Control Board's decision to issue a permit. Just as Roy was saying, what you don't want to have happen, that's what happened in this case. So they successfully challenged the issuance of this permit for a pipeline compressor station in Union Hill, which is a majority Black community, substantially inhabited by the descendants of formerly enslaved people. And the Fourth Circuit vacated this permit, and in doing so admonished them with this sort of now famous quote that environmental justice is not merely a box to be checked. And so that's just a great example that, just to make you aware, these permit battles are still ongoing. There are stiff headwinds. I won't lie to you about that, but there are successes that we've seen along the way. And again, some of these new permitting regulations and schemes that we're seeing, regulatory schemes that we're seeing crop up in state legislation are really powerful. Roy mentioned New Jersey, but I'll also, and one thing just to drill down on that for a moment that I had in my notes to mention, with not only that it mandates the denial of a permit, if there are cumulative impacts on communities with environmental justice concerns, again, not only for newly proposed facilities, but permit renewals. So what's powerful now is that we're getting at this aspect of cumulative burdens that we've touched upon a couple of times, and these aggregate risks, because it's very rare for these risks to occur in isolation. And it's one of the things that stymied progress so far for environmental justice, because a new facility can meet a regulatory threshold, but when you add that facility to what's already there, that's the problem. They're all happening in the same space. That's the problem. And so that's why that type of analysis is so important. But we're seeing it crop up as well. New York, Massachusetts, Vermont, Washington State. And I want to give you all another tool in this room. If you're interested in a fantastic tool to identify state laws, policies, regulations, constitutional amendments, executive orders that touch upon environmental justice, look at the Environmental Justice State by State. It's called Environmental Justice State by State website. Just an excellent tool. It will make all your research a lot easier too, because it's just really wonderful. I have a couple of other examples as well from the NEPA context, which mandates sort of thinking about analyzing and distributing information about projects that could significantly affect the environment. I'll just mention briefly 2 touch points there, and then I'll stop because I feel like I've been going for a while. So that's what NEPA does. And then there are state mini NEPAs that require the same thing. And again, they're requiring the examination and the disclosure of environmental impacts. It does not require the selection of the most environmentally friendly or just way forward. Right now, it's still being read as just a procedural mandate. But nevertheless, we continue to see environmental justice challenges to basically every part of that decision-making process, from the distribution of information about a project. So there's a famous case where there was a proposed sited facility in a county where 95% of the people spoke Spanish. Okay, well, you have to distribute that information in Spanish then. Okay, so it seems like common sense, but there was litigation about it and the community won there. And then, of course, there is what is now famous, and I sort of am going to assume that everyone in the room has heard of the Standing Rock litigation. And so that's an example of a challenge to a decision that there would not be major impacts. So it's sort of challenging the end of the decision. And I bring up that case. It's a very long-standing litigation battle there, but an example of how even when there's losses, and there was a win, we'll see what happens with the permit ultimately, but even when there were losses along the way, again, going back to the non-litigation, the non-winning value of these suits. I mentioned the launch of Dr. Robert Bullard before. Here, the Standing Rock litigation really animated and spurred not just a movement within the United States, but I would say really a global movement, a global awareness and attention to the terrible and ongoing and widespread intersection between extractive industries and indigenous populations. So there is, on that note, I'll just conclude by saying we see the attention really across the spectrum in the environmental practice world. It's exciting. It's an opportunity for creative thinking, as I said, but it's hard, and those headwinds exist, and trying to fit inside these litigation pathways is tricky, but there's space for creative and vigorous advocacy to move it forward.
And I will just build on that, since you mentioned Friends of Buckingham, which someone had asked, the Friends of Buckingham v. State Air Pollution Control Board, the 2020 decision from the 4th Circuit.
Yeah.
I think it's a case that colleagues of mine at SCLC and at the Chesapeake Bay Foundation worked on behalf of Friends of Buckingham, which was the organization representing the residents of Union Hill. And it reflects, I think, 2 things that we've sort of touched on. One is the sort of creative, litigation, creative, there was not an environmental justice statute that Friends of Buckingham was trying to enforce. There was a state statute, or state site suitability statute, that basically said that the board needs to determine that the site is suitable for this gas-fired compressor station, and needs to analyze the character or degree of injury to public health and safety. So it doesn't say anything about environmental justice. It doesn't say anything about race. But in that case, the parties actually agreed that and another policy in Virginia did require consideration of whether there was a disproportionate impact on people based on race or other factors, and the court endorsed that. And so that was, an example of saying, okay, we can't just come in and say environmental justice, we win, but what can we use in the existing law to raise those arguments, and ultimately in this case to get a permit thrown out. The second thing that was important in that case was the stories of the residents of Union Hill were sort of front and center in the case and before the court, and I think really mattered to the the three judges on the panel, as you said, they were, a few generations, they were of the same families who had been emancipated from slavery and who had bought property, often on the site or near the site where they and their families had been enslaved, and then their descendants still live there several generations later, and it's a very rural community, and it was where the pipeline company decided that there needed to be a compressor station going through as part of the Atlantic Coast Pipeline, and they're raising these concerns about the air pollution from their asthma and their way of life, and citing their history and the history of this community was a big reason why the case happened in the first place. And also, I think, I'm not inside the judge's minds, but I think it certainly made a difference.
Oh, I absolutely think it did. There's just a devastatingly well-written paragraph in the decision where the judge is right about the history, and they say this is where these people buried their dead for generations, period. And this is where, they wanted the pipeline compressor to go. And when we talk about the case in class, I use that as an example of and sorry to go off on like a teaching tangent here for a moment, but I use this as an example in advocacy of the adage, show, don't tell, because you don't need anything else besides the judge's description of this is where they buried their dead for generations, and then this is where the pipeline the company decided the pipeline had to go. Right there, it's over for the company, without the judge having to say, how much this bothered them that they made this decision. And it's just a really, it is such a powerful case, and the residents, just worked in conjunction with the legal groups that you mentioned. They were there at the meetings, the residents spoke at the meetings, they supported them in doing door-to-door survey work to get a more accurate depiction of the demographics in the area. So it's really just, it's a model, I think, moving forward for how we should try to do these cases. Yeah.
And that was actually leading to a question I was going to ask you to. The door-to-door survey was really important because for a while, both the pipeline company and the state had either said there is no community of color, or no environmental justice community here, or we're just going to assume that there is, and then go on to the next stage of the analysis, and having that actual data from people literally going door to door in the community and getting the stories of people there was really impactful. And that seems like one of the challenges. I know some of the state laws that do require in permitting or otherwise consideration of environmental justice have some sort of trigger about the community, about whether there's a certain population of people that meet a certain description, or that demographics, whether it's income, whether it's race, and compared to the county or compared to the state. So sort of defining what is an environmental justice community in the first place becomes the first step you have, the first hurdle you have to meet. Is that a challenge in terms of, should we be thinking expansively about who environmental justice is protecting, who it covers, and relatedly, and you can take any form of this. We talk a lot about hearing from the community. Well, the community, as you mentioned before, Roy, is not usually monolithic. It might have a number of views. How is that a challenge, and how do we address that, hearing from as many different voices in a community or communities when we're dealing with these issues?
Sure. So, Sarah, I know you probably have examples of actually sorting through and trying to even parse out and figure out how you would even go about determining, defining a quote unquote environmental justice community. We have some, proxies that we use to at least give us an initial idea that maybe we should look closer at, what's going on here, who's here, what's the history. But the truth is, the intent is to view it as expansively as possible, right? While, the initial issues that, kind of in the history that Sarah recounted, was looking at a lot of times impacts to Black communities and what they experienced, it goes far beyond one particular group, one particular race, one particular characteristic of that population. I told you, for example, with the CGIS tool, it's looking at educational access, right? That doesn't touch any particular racial group. It's just a matter of, here is something that can cause disadvantages to a particular population. And so they're more vulnerable than the other populations in that state or city. And so as you're considering whether you're dealing with an environmental justice community, you kind of have to make the effort to look at all of those different aspects of the community, because many times there is at least some dynamic there that suggests that there's risk or vulnerability there, and you want to make sure you're aware of those vulnerabilities, because that also informs how you go about mitigating potential harms, right? And so the short answer is look at it expansively, but it can be incredibly nuanced, right? Because not only are the communities not monolithic, the priorities that any particular group within that community has they can vary. And you may not be in a position to, let's say, address all of them in a satisfactory way. And so then you have to kind of triage as well to say, well, where is the most significant harm being felt? How do we address that? Are there ways that we can also address some of these other concerns? But it's challenging, and it requires a pretty significant amount of collaboration to actually get to that place.
Yeah, I think I completely agree with everything you said. And there's I've mentioned this intersectionality lens that I take, which, by the way, I take no credit for that. That is Kimberly Crenshaw, who talked about intersectionality. So that's all her. But I use that as a lens when I think about this work. But just to mention, how difficult this really is. Sometimes, education is a barrier. Sometimes, as Roy, I think, mentioned, linguistic isolation can be a barrier. Think about internet access as also being a barrier, which we can end up dealing with that a lot of times if there's rural communities on reservations. And I'll just add that another dynamic that we're always thinking about when we're thinking about communities with environmental justice concerns is who has been historically marginalized in decision-making processes. So again, just as Roy said, it goes beyond any single characteristic of a person or a community. But one thing to think about is historically how they have been treated by processes of power and government decision-making processes at all levels of the game. In terms of trying to address community concerns as broadly as we can, I think there is a playbook of best practices that is pretty expansive and developing, and we need to keep pushing at it. And to get at those best practices, we need to have a lot of dialogue. It's happening, but we try to get people together in convenings when we can to share best practices, but it is a lot of identification work before the door-to-door work. So identifying affected populations is really important as a first step. And then there's sort of trying to figure out door-to-door, who should we be contacting? Do they have internet access? Great. Are they willing to take a survey? Great. Sometimes there is distrust, big distrust issues between these communities and government actors. And you need to think about the identity of the person who's knocking on that door or sending the survey. Because that distrust is rooted in oftentimes historic mistreatment, tokenization of people's concerns. But if you can get something like, let's say, a community survey going, then sometimes you can start very open-ended. What are your concerns? What are your experiences? And then from there, start to whittle it down. And I've worked with people from there. You develop a menu of options. What are you most concerned about? What are the solutions you'd most like to see based on what the community has identified? And then you're starting to try to narrow it down. And that gives you a better idea of what most people are concerned about. Again, these communities are not monolithic. Not everyone feels the same way about everything. I'll just add quickly, it can be really helpful to identify trusted leaders in that space, whether it's, sometimes we worked with religious leaders in certain communities. Sometimes the community is really well organized. We work with a great community group in DC they're really well organized. Their leader is fantastic. And so that makes it a little bit easier as well. But those are some strategies that I've seen be successful to help identify those concerns in a challenging space that's dynamic and nuanced.
I'm pulling, there are a number of questions that we've gotten from the online crew. I won't be able to get to all of them, but I'm going to pull from some of them and also invite at any point if you want to solicit questions from the room, or people can raise their hands as well. I'll ask one and then I'll come. Actually, you have a mic there. Let's go to you here in the room.
There, use that so people online can hear it.
Thank you. I have actually two questions. One is with the Sarah and second with the Roy. Sarah, as you were mentioning on environmental justice historical timeline, is there any time when the environmental justice leadership thought to come out from the civil rights and take this case to the criminal court?
Mm-hmm.
As you mentioned, and historically we have seen in 60s and 70s, product-related diseases and injuries has been tried, class actions, and several statutes has been made during that period of time. Just for example, smoking is one of the biggest example if we look at the litigation history.
Mm-hmm.
And as in the similar way, you talked about the air pollution, how we can smell it, but we cannot say that how it's badly impacting on the human health.
Mm-hmm.
Now in 2024, we are experiencing UNICEF is coming out with a report, bringing the evidence, AQI and several other institutions who are measuring that the average human life is reducing 7 years or multiple other dimension also coming up. So the first is the criminal one. The second is the product related thing. The Roy, I have a question. You mentioned that ESG is a buzzword. I had a chance to go through the Inflation Reduction Act. There is nothing talk about the institutions who are providing the investments, BlackRock, Bank of America, to the companies. And there is nothing talk about how these institutions will come under the regulation, or they put themselves as a best good leader to make such practices that they are really committed to protect the environment, or have a bold statement on not pursuing the investment on fossil fuels, for instance. I have seen in a UNEP the last February in Nairobi, they are coming up with a global new move. Instead of focusing on fossil fuel, they are diverting the attention on methane, coming up with a new legislation, multi-stakeholder solutions on methane, and not talking about the carbon dioxide and not talking about on fossil fuel. Similar pattern, the act doesn't talk about that. So Elon Musk is one of the leader in this country, is talking about it's a socialism, ESG. So if such leadership is just exemplary working, and then whole institutions are following that equation, maybe how do you see that will work? And similarly, the country like US, where 21% GDP comes through the government side, and the rest is the private sector and the capitalism, and you are just focusing on regulations, it's only on 21%, and what about the 79% if ESG is not imposed or not regulated well or documented well, then 79% investment will be nowhere. It's damaging the community, environment, and everything. Thank you.
So the role of criminal law.
Yeah.
And then ESG investment, what intersection does that have with? our environmental justice.
Sure. So I heard two parts to the question that you had for me. And the first it is about the role of criminal law. So that I think is goes to Roy's earlier statement about the whole of government approach under the Biden administration. And so one of the things that's happened at the Environment and Natural Resources Division of DOJ, where Mark and I worked, is they are taking a really holistic approach to this, and their client agencies are mainly EPA, but they work with a lot of different agencies depending on the section that you may be in. We worked mainly with EPA, and there is an environmental crimes section within DOJ. And I think it's really telling that the administration tapped David Ullman to lead at OECA, which is the Enforcement and Compliance Assurance Group at EPA. David Ullman is the former section chief of the Environmental Crimes Section. He knows how to do this work. He knows how to leverage the criminal provisions in our federal environmental statutes to make this work. And they are working on that from an environmental justice perspective. So the triggers, just so you know, the triggers in environmental criminal provisions tend to revolve around what's called knowing endangerment. So they have a different standard than the strict liability, which doesn't require any mens rea in the civil liability side of things. I had the opportunity to clerk in the environmental crime section when I was a law student at Georgetown, and worked under Dave Ullman at that time. And I can tell you they have the best person leading OECA on this. So that's a really good thing that we're starting to take that lens to it and identifying where there can be knowing endangerment, specifically in communities that have felt the burden of this pollution for a long time. The second part was about just the impacts that we're feeling long-term to the average human life, you mentioned. What that brought to mind for me are some of the state constitutional claims that are being brought by youth plaintiffs right now. So I would commend a couple of sets of litigation to you to check out. These are decisions. So one arose out of the state of Montana. And there you have youth plaintiffs alleging issues, infringement upon their right to a clean and healthy environment, and the agency at issue failing to think about how future generations would be impacted by their decisions. And that stems importantly from an amendment to that state constitution. We see they're called green amendments. And we also saw that in the state of Hawaii, and they just settled a really big case with youth plaintiffs over climate change and its impact for future generations. So look at those two cases. And then for everyone else in the room as well, when we think about the advocacy that we can be doing, green amendments is a huge place where we can push. And there's constraints. You can't amend state constitutions willy-nilly. There's constraints on what type of amendments and how that can all be brought to bear in the state constitutions. But that's a really powerful lever for change, and we're seeing that. So Montana and Hawaii, check it out.
So just to piggyback on that, the point about criminal aspect, I mean, I can tell you firsthand that the DOJ, particularly under Dave Ullman, is already actively pursuing criminal prosecutions under the environmental crimes provisions, specifically related either to impacts to certain communities, related to activities where the actor knew that they were going to have that of impact and basically did it anyway, either because it was expedient or because they were not, giving enough attention to it. But there have been, and I believe he had a memo maybe a month and a half ago where, it was basically just a list of here are the prosecutions that we've resolved already, where, sometimes it's, fines, maybe not people, going to prison, but significant penalties under the criminal provisions actually related to certain activities and were connected to addressing environmental justice related concerns. So that is actively going on, at this moment and continuing. On the ESG piece, I think that one of the challenges of looking to ESG and trying to think about how that speaks to or is incorporated into addressing EJ is that ESG is primarily just a framework for investors to decide what companies they think are worthy of investment, right? Before there was ESG, then you just had things like, corporate responsibility or, social governance. And so there are always these frameworks that are being used. And I think because environmental justice does touch on such a wide range of things, there's an EJ lens that can be applied to investing decisions. But that's not going to drive advocacy. It's not going to drive what a state or federal government is going to impose on private sector entities or other actors to actually have those things be addressed. But it is useful as a lever to pull to find other ways to exert pressure, right? So you do that through the large investors, like for example, you mentioned various banks, but also through even just individual investors who hear publicly now, based on things that are now required to be disclosed, here are the impacts that our operations are having, or here are the areas where we have gaps in terms of addressing certain concerns for the public. Ultimately, I think that, and this is my speculation, right? So ultimately, I think that the ESG focus, whatever it ends up being, because it has shifted since it first started and now the direction it's going, and now there's anti-ESG and there's all these other ways of people trying to view how to evaluate what companies are worthy of investment and which ones aren't. That fundamental attention piece that I spoke to, that's still going to be in play. And so, whether it's from the top down, from, major institutional investors, major corporations, or if it's bottom up from communities, or somewhere in the middle where you have, government agencies, other organizations, some companies that have basically made it part of their culture to actually speak to those things now that they are giving it more attention, that's going to continue kind of irrespective of where those investment dollars go. And now there's language to speak to when you're looking at what a bank has invested in most significantly, and what that says about the company, and whether that's something that should be weighed into an investment decision. And we're seeing now more requirements in terms of what companies are expected to disclose about those investments. And I think that's going to then create more transparency, where people will be able to make determinations and decisions or raise concerns when they do recognize that an actor is, let's say, acting inconsistently with what the public would prefer in terms of protecting public health and the environment and addressing EJ related concerns.
I'm going to turn to, and I will take your question. We will also be able to stay for a little bit afterwards. So if I don't get to questions from people in the room, something that the people online don't have the ability to do, welcome the chance to talk to you. But I wanted to ask, because a couple of questions, or a number of questions, came up about on the federal level, and I think we were maybe hoping to get through this without talking about the Supreme Court, the demise of the Chevron doctrine and the local right case, and without going into sort of a deep analysis of that case, is because we got a number of questions, I think we can avoid it. What do we see? How do we see the decisions, especially from this term from the Supreme Court, especially Loeb or Bright, and the drawing back of levels of deference to federal agencies that, in some senses, have been somewhat at the forefront of whatever environmental justice, regulatory, or legal structure there is. How do we see that affecting the fight for environmental justice going forward?
Okay, I'm going to be. I take it that maybe I should be brief, based on the queue. I could talk about this for a long time, because this is something I spend a lot of time thinking about, and I don't think we talk enough. So the first thing is, we don't talk enough about the environmental justice impacts of all these decisions. Another really important thing to say is, it's not just Chevron. So the overruling of Chevron has a lot of impacts when we think about the way agencies will make decisions, and the quote unquote deference that they may or not receive, their the due respect that they might be accorded. I'll just say that relates broadly into a big problem that I'm seeing, which is as decisions, not just this one, it's this one plus all the other decisions that have come out this year, last year, the year before. they are amassing power to the judiciary. And so as we put that power into the hands of the judiciary and away from expert agency decision makers, now you get forum shopping. And we're in a very intense period of forum shopping. And so you certainly will have some judges and justices who will exercise judicial restraint and humility. And I think others who will not. And they will take this opportunity to make their own decision about what things mean. And that's always dangerous. We are seeing judges as well try to write these decisions that bind not just the agency before it, not just the jurisdiction that they're in, but really aiming for things like nationwide vacature of rules, nationwide stays of rules, really just big aims of these decisions. And so the first thing I'll say is it's not just Chevron, it's Chevron and it's the overruling of Chevron, all the other administrative and environmental decisions that came out this year. Let's reach back. Let's look at West Virginia versus EPA that introduced the major questions doctrine, that term. Now suddenly you have any new use of authority that's going to be challenged as a major question, whether or not it actually has significant consequences economically and politically. That's a real problem with environmental justice, because people are now starting to identify environmental justice and try to use existing authority. Well, if you're using it in a new way, you're going to get a major questions challenge. And so collectively, I would say these decisions, the most succinct way I can put it, sorry, I could talk about this for a very long time. Collectively, you should just know, there's no way to get around this. This will chill progressive administrative action on environmental justice that is long overdue, and we should all be very concerned about that.
I think you covered it very well.
Well, no,
Well,
go ahead.
just in the interest of time, I don't want to. Yeah, well, I don't really have much to add on top of that. That was really thorough. I mean, I think ultimately, I agree 100%, and it's really going to be a circumstance where I would expect, because some of that groundswell of activity I mentioned before that we're seeing, from states, cities, things like that, where now there may be even more of an impetus for there to be legislation, because that's the only way that you get around, unambiguous legislation is the only way you get around a judge kind of just imposing their own interpretation that they want.
Yeah.
So, not from the federal level, because they never pass anything, but I'm kidding. But yeah, I think that we will, at least in certain jurisdictions, I won't be surprised if you see that really get pushed forward.
We had a question about, because we mentioned community benefit plans under FERC's scheme, and just explain a little more about how those work. And then there was a specific question about whether they would apply to ancestral lands of indigenous communities, which might be something that you thought about or haven't thought about before, but I thought it was a really interesting question.
So the applicability totally just depends on where the proposed project is. So if it's in a location in the vicinity of where there are indigenous peoples, and I know that there have been projects proposed that are, then that would be expected to be woven into the community benefits plan, because they're part of the community.
And can you explain also just
So
take a step back, yeah.
effectively, a community benefits plan, and I don't have the pillars listed, but there are essentially, I believe, 7 pillars that need to be addressed in the plan to show that there's consideration of and steps being taken, concrete plan to actually provide benefits to those particular communities that have been identified. And I gave a few examples before. So whether that's jobs being created, specific, essentially infrastructure being created that may not have been in place before, and also a time horizon for when it's going to be done. So there's actually very specific requirements to, not just make promises, but actually here are the organizations, here are the contractors that are doing this, here are the organizations that we're working with locally to make sure that it happens, here's the time frame for us doing it. And then there are essentially milestones that funding is released as those milestones are hit. And so that's really the kind of overarching way that they function. And as it, like I said, for indigenous peoples or any other community, if the project is located somewhere where there's an indigenous population within that community, then there would be a need to address that, including for example, you mentioned like burial grounds, for example, efforts to avoid or recognize that those burial grounds are there. Sometimes, it takes a number of different forms. Sometimes there are specific areas designated where there will be no development. And it's agreed, effectively in perpetuity that they won't, even if it needs to expand the project at some point, it won't be there. Those kinds of promises are also kind of put in place as part of essentially making the plan for using the investment or the funding that they would get from the federal government.
I want to give you a chance to ask your question.
Thank you. I think you guys covered a little bit with the Supreme Court decision, but my first question was how, if there's a change of administration from the Biden to a Trump administration, how will that work impact you? And then the second one, in your experience, Roy, working with companies, I feel like everybody that hears cumulative impacts turns away and wants to not even want to consider, right? The compounding effects of on health and people and many things like that. How has it been in your experience working with companies that don't want to consider cumulative impacts, especially in states like the cancer goals, Houston, Texas, Louisiana, Georgia, Alabama, you name it, where their local politicians are turned away into the companies and industry? How has that worked for you?
So I'll answer the second question first. So one thing I will say is it may not be visible to you, but many of those companies are actually considering those things. But what they don't want to do is create expectations about what they're going to do. And so they essentially keep it very much internal. There has been a groundswell of consultants actually that have become expert at conducting those analyses. And so now they have resources that they can go to better understand what's even meant when someone's talking about cumulative impacts. Lawyers naturally, particularly for a company, when they hear things like impact and cumulative impact, they're thinking about causation and they're thinking about liability. And so the first thing they worry about is if I do this analysis and it says, well, I only contribute, 8% of the total impact, but the impact to this community writ large could be valued in the billions of dollars. Am I now raising my hand to say I am responsible for paying out X billions of dollars to this community? In certain instances, maybe yes, but that's where the fear comes from. But they also want to understand it because it could also be the case that they're contributing 90% of that impact and they don't want to be in that position. And now there are, again, many more consultants who actually can crunch the numbers, do modeling and really figure out what the actual impacts are relative to all the other sources that are out there, which then enables them to engage better with the agencies and the communities to actually explain, here's what we're doing, here's the impact associated with what we're doing, here's what we're doing to mitigate those impacts. Because oftentimes, at least what I've found is many of the prior impacts relate to activities that aren't really actually occurring anymore. And so you have to figure out, how do you address those impacts as well? Because that community as it sits has experienced what it's experienced, and you can't come in and say, well, I didn't do those prior things, so I shouldn't have to factor that into what I do now. That's not how it works, particularly if you're actually trying to consider environmental justice, right?
I'll just add that that permitting authority will also say, well, I'm looking at an air permit. I don't even have any authority to say that all of these pre-existing land and water impact or ongoing water impacts, I can't do anything about that. So that it's just a huge challenge.
And that's what makes it, right, that's what makes it that much more complex. And that's why, at least initially, when cumulative impacts is said, it just, almost kind of makes people's eyes roll back because they're like, I don't even know, I'm overwhelmed trying to figure out what that means in the context of what I'm doing. And sometimes it's simpler if you're just talking about air and you have emissions data going back however much time to crunch those numbers. But sometimes it's a lot more complex than that because there wasn't reporting on what activity was going on. You have to actually learn some things from the community about, oh yeah, 20 years ago, there was this one junkyard and they had this dump place where they dumped things for, years. And actually it wasn't permitted. It wasn't actually allowed, but it actually went into their water and you need to be able to account for that as well. So it's very complex. It is the answer, but it is being looked at least with the clients I work with, because I tell them they have to. I mean, and that's really ultimately from my purposes, advising them, it's a risk mitigation tool as well. I mean, the idea that they'll be able to just kind of close their eyes and hope it goes away, and then they won't have to deal with it. That's just non-existent, because I told you that attention piece has increased significantly. So at some point, it could be, years from now, someone may ask the question, well, it looks like this is an impact that's been occurring here. Did you look at X, Y, and Z? No, why not? I didn't think I had to. That's not really going to be a satisfactory answer at this point, right? So, yeah.
Yeah, you all are asking the questions that I like, that keep me up at night. So, so what happens if there's a change in administration? A lot of things everywhere all at once, right? So there's so many, so we could talk a lot about this afterwards too, but I'll just name a couple of things that will happen immediately. One is revocation of the executive orders that were mentioned immediately, issuance of new executive orders, I imagine greatly constraining what agencies can do. We've discussed a couple times about the all of government approach. I imagine that will vanish immediately. So these agencies, we've been talking a lot about EPA, but these other agencies deserve to be mentioned. Department of Energy, DOI, NOAA. I mean, these are agencies, DOE having a big intersection with some of the things that you were talking about before, the permitting and whatnot, and these community benefits agreements. All of these agencies have made great progress in the last few years. And so we should rightly be very concerned about that evaporating under a Trump administration. Just so you all know, a lot of things like enforcement policies, for example, those are just issued by the agency. Their guidance, they're non-binding, and they can go away with the stroke of a pen. I mean, the Biden administration did it too. Gene Williams, who is a career Deputy Assistant Attorney General, was able to say the previous administration's policies saying that you couldn't use supplemental environmental projects for enforcement cases. That's gone because we think that's wrong. I mean, I personally cheered that, but it was a quick way to get rid of it. The same thing will be true if there's a new administration. There'll be rollbacks of regulations. There'll be new rules issued. And so for us, it will, on the public interest side of things, it will mean challenging the new rules. There will also be a freeze on the defense of Biden administration era issued ruhave. So, for example, you saw the EPA promulgate a raft of new rules this spring. Those have all been challenged. And so if you look carefully at that litigation, you'll see that there's lots of interveners there. Those people are there. I mean, there's lots of reasons why you might intervene. One of the reasons why you might intervene is if there's a change in administration and the new administration won't defend the rule, the interveners are there to defend the rule. And so that litigation can continue.
Can apply there too.
Yes, yeah. So anyway, so there's a lot more than that, but I'll just say one more thing on a positive note, which is that's why you see so many people saying it's not just about things that are happening at the federal level. These state advances that we've talked about, local level advocacy, those are our bulwark against federal retrenchment. That's the best that we have, and it's very good. So we should be thinking about action at all those levels to serve as that bulwark against the federal retrenchment. So we can remember at the state level, there's still enforcement, there's still citizen suits, there's local zoning and land use processes that we can be involved with that are so critically important and can keep advancing environmental justice regardless of what's happening at the federal level.
And what about all of the federal funding that right now is potentially available?
Don't ask that question. Nothing will happen to it.
I mean, are there any guardrails there? Is there anything that could keep that coming, or is that also at risk based on the results of the election?
So what I will say is that everything's at risk. But
Everything there.
everything's at risk, but there are certain guardrails in the sense that certain money's been earmarked to be used in a particular way. And so that money can't be used in any other way. However, if it hasn't been used, it could just be set up, right? That's the real challenge there.
Yeah.
Now, it will be interesting though, because, at a certain point, there could be conflicting priorities, because some of that money that's being leveraged is for projects and development that is really bipartisan in terms of what people actually want to see occur. And would you tie up, facilitating those projects just because it's coming through funding that you otherwise disagreed with? So there may be some things that squeak through because of that, but otherwise, it's not that difficult to just, accept applications, but then not actually award any grants. So.
Yes.
If I may, hi, my name is Allison Waters. I am the U.S. Department of State's Environmental Justice Officer. And
Thank you for your service.
It's fantastic. I really, really appreciate this. My awesome intern is here as well, and we're just really excited to be working on a variety of these projects. I would be remiss if we didn't mention today that tomorrow will be the White House's first Environmental Justice Summit. It'll be occurring at 11 a.m. and it will be live streamed. So please take a moment. If you're really interested in this conversation, then tomorrow's announcements will be, I think, really relevant and timely. There'll be a plenary session and 2 panels, and then participants at the summit will also be doing roundtables that will really be interesting. And most of it will be live streamed. So really highlight that. And I just want to thank you for taking the time to really educate and inform the entire audience, because this is just so incredibly useful. As policymakers, we jump into these different topics and really depend upon so much of the people that are just really focused on this for decades. So thank you so much. And I'll follow up with some questions afterwards.
Thank you so much, Allison.
Thank you.
Yeah, just had a question, following up on what Roy was just saying about the sort of intersectionality and bipartisan aspects, and then a little of what Professor Colangelo was saying about intersectionality of the movement in general. I was lucky in like 2017 to listen to Bobby Seale give a speech about sort of the intersection of environment, civil rights, but also labor. And so I'm wondering to what degree you all see the labor movement sort of intersecting with environmental justice as a way to kind of leverage that bipartisan aspect.
Yeah, I can start, sure. No, I mean, I think that this is something people have been thinking about for a long time. And labor, I think, touches upon a lot of different types of concerns within the environmental justice movement. And in fact, some of very early cases, again, I don't even think that the participants would label it environmental justice, but had to do with agricultural workers and disproportionate exposures to pesticides and things like that. There's also a lot of issues there in terms of the characteristics and the marginalization of workers who are out there, who may be, especially in that agricultural sector, exposed to just really tremendous amounts of heat is one of the things that I'm thinking about a lot when I think about this. But again, we could look also at people who are doing all types of work, all different types of exposures. And I think that this is, the more powerful that movement becomes, the labor movement, I think that can help environmental justice when we look at it through a health justice lens. And the same for environmental justice. So just a bit, I have written this paper called Bridging Silos, and it's about the link between environmental justice and reproductive justice. It's not out yet, but I'm happy to send it to anyone who's it's forthcoming. But that it touches upon reproductive justice as well, because we think about pregnant people in the workspace and what do their protections look like as well from a health perspective. So there's a lot of intersections there. It's very complex. I'm a proponent of getting these movements to talk to each other. I believe that as we increase people's self-determination, their autonomy, and their awareness of these threats in both movements, sort of a rising tide lifts all boats, but it's still complex. There are dangers when you say, hey, all these movements should join together, everyone should talk to each other. Well, sometimes the leadership, they're exhausted. They've been doing this work. And now we're saying, hey, look over here. Think about these different touch points as well. We're giving them more work to do. There's potential downsides if there's dilution of movement identity. Some people, I think, are rightly thinking about that too. So while again, as I said, I'm a fan of bridging those silos and getting people in these different movements in dialogue because there are such clear touch points. I think maintaining some separation will always occur.
So I was going to touch on the very last point you raised, which was in relation to dilution and also the identity piece. I think it's always good to be coordinating, collaborating, understanding what issues various groups are dealing with so you can find those synergies and figure out how you can collectively advance, right, environmental justice. But there's also a need to be careful that any one particular group's identity or priorities get centered in the process that then undermines kind of what other groups were trying to pursue. And that's been, a dynamic that has existed for environmental justice when you just talk about conservation or other issues, right? So that's always the case, but I do think that the value of having the collaboration and the coordination and discussion is going to benefit any group that's taking that broader lens because it is so intersectional ultimately.
I didn't know if I was getting a cue from.
Yeah, sure. Well, thank you all so much for coming out today. Thank you, Mark, Sarah, Roy. We so appreciate it. For our in-person audience, you might be able to catch the panelists really quickly if you have more questions. For our online folks, thank you so much, and we hope to see you next week for the last session of summer school. And this session was recorded, so if you'd like to watch anything back, you can as well. Thank you so much.
Right.
You want to come? You're ready to come speak to my class?
Well, of course. As long as I can get you to speak to mine.
Fantastic.
Well, you can just come recruit.
Yeah, I'll do that. Okay, I'll do that.